Now suddenly probate has to happen. Your creditors are getting involved, and they're reaching back and trying to pull that money from the people who got your money through these beneficiary designations, and it's a free-for-all. Hi, this is Jeff Mersace, the Plain English Attorney, and this may end up being a bonus video. I was tagged in a Facebook post by my wife, and apparently it's spreading out on estate planning, and even though we've got a couple of other reaction videos lined up, I felt this one needed some immediate attention. So let me just go right into it and start talking about how some of the things are right. There's a lot that's only a half-truth or a myth, and it's coming from an American Legion post, and I'm going to black out the specific one because I don't think they were intending to do any harm. I just don't think they've got all of the information, and they do have a good intention here. It's just, okay, it's not accurate. There's a lot that's actually wrong with it. So let's jump right into it. Spreading this information for those of you that don't have your affairs in order, make sure all bank accounts have direct beneficiaries. The beneficiary need only go to the bank with your death certificate and an ID of their own. Wrong. Just no. There are a lot of banks and other financial institutions, especially ones that are like doing brokerage accounts and mutual funds and whatnot, where they are now requiring letters testamentary from the court. So you end up having the probate court being involved in some way. And if you go ahead and ask a probate attorney, they go, oh no, it's not in probate. No, but now you actually have to go to the court and get that process started and deal with getting the letters testamentary or the letters of administration when it's supposed to avoid all of that. So that is definitely not accurate. The other thing is, if you name beneficiaries, let's say you've got 3 bank accounts. You've got a stock account. You've got a mutual fund and an IRA and a life insurance policy, and you've got 3 kids listed as beneficiaries on that. What if one of your kids dies before you do? Nobody wants to think about that. You can put, oh, well, no, it can say per stirpe, so it goes to the grandkids. That 1/3 would go to the grandkids. What age are they supposed to get it? Oh, well, all of my grandkids are like under 10 years old. Yeah, so now they're going to get that money when they either turn 18 or 21. So these beneficiary designations really don't protect the beneficiaries until they reach a reasonable age. And they're not going to handle a lot of other contingencies. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. What if one of those kids or one of those beneficiaries is either disabled, or a person lived a long life, but one of their kids is already in a nursing home, and Medicaid's paying for it. All right, that goes directly to them, and it messes up all of that. That's a very real possibility that's not planned for by using those beneficiary designations as the end-all be-all. And like they put in here, look, it's not that simple as you walk in with a death certificate and your ID and it's done. Plus, the plan is just very disjointed. What if you want to make a change because one of your kids did die? Well, now you got to go to all of those different bank accounts, and you've got to go to all the different stock companies. So there's 3 bank accounts. There's the stock brokerage account. There's the mutual fund. There's the life insurance. There's the IRA. All of that has to be changed. Whereas with the coordinated estate plan, preferably with a revocable living trust to avoid probate, You bypass all of that crap. You only have to change the trust and it's done. All right, TOD, transfer on death deed, if you own a home. Completing this document, it's a deed. It's actually a legal document. So yeah, you can always try to do that yourself, but that's ridiculous. It never ends up right. You need an attorney to do that. Completing this document and filing it with your county saves your heirs thousands. This document allows you to transfer ownership of your home to your designee. All they need to do is take their ID and your death certificate to the county building, and the deed is signed over. No, it's not signed over. It's yours, but there's no deed stating it's yours. Yes, you filed the death certificate, but now you're actually going to either get some kind of deed to place it into your name if you're going to be living there, but maybe you want to get a mortgage out on it, or if you're selling it. All right, there's paperwork and there's a process around that. Yeah, it avoids probate, but it's the same issue. What if it was that person passed on, or they need or are receiving Medicaid? Either they get kicked off of Medicaid for nursing home care, or that's their primary residence now. Yeah, it's exempt, but we can put a lien against it. And now Medicaid will end up claiming that property. Again, if you have a revocable living trust owning the real estate, it can go to the beneficiaries. You can have all the different contingencies. You can have the age limits and whatnot. It's just, yes, they want to avoid probate. This is one of those duct tape solutions that really isn't the most efficient way to do it. Living will allows one to put in writing exactly what you want done in the event you cannot speak for yourself when it comes to healthcare decisions. Well, that's not actually accurate. It allows you to put in writing the end of life decisions. So we're talking in a living will, we're really talking about withholding life support and artificial nutrition and hydration, denying care at the end of life where it's like, no, let me go. It's those types of things. You can have advanced directives like, if I have dementia, I don't want this particular type of treatment, I don't want to be intubated. And yeah, you can put that stuff in, but it's a little sweeping to say it's what you want done in the event you cannot speak for yourself when it comes to healthcare decisions. Right? The durable power of attorney allows one to designate a person to make legal decision if one is no longer competent to do so. That's true. It's probably a much shortened version. I kind of call it a financial power of attorney. It allows them to stand in your place and handle financial and legal decisions, so you're able to work with the bank on a bank account that's in your name, although that's an issue. Some banks are not honoring those. Well, wait a minute, why aren't they honoring those? Oh, well, it's got to be on our form. So if you've received any of those, that really, really small print that here are some changes to your account, it's entirely possible that your bank said we will not honor any power of attorney documents not previously filed or on file with our bank. You must use the one that we have on a form, otherwise it will not be honored. And they'll force you to go and get a guardian or a conservator appointed by the court in order to deal with things. Again, if the account's in the revocable trust and you've got a trustee, you don't have to worry about that part. Right, so power of attorney for healthcare. This document allows one to designate someone to make healthcare decisions for their person. True, and again, very shortened. There seems to be, in their explanations here in the post, a little bit of an overlap of what the living will and the healthcare power of attorney does. The healthcare power of attorney is designating someone and laying out the authorities they have. And preferences for treatment. That's not in a living will. Preferences for treatment, again, other than end of life, are typically in that healthcare power of attorney. Now, the way I look at it, look, if you trust someone to make healthcare decisions for you, give them all the power and authority to do everything that they need to do, use their discretion. It's just that very end of life stuff where you doing the living will isn't so much that you don't think they're going to carry out your wishes. It's more that you don't want to put that burden on them, and therefore you're going to have the living will. Last will and testament designates to whom personal belongings will go to. Oh my God, that is probably about the weakest explanation of what a will is. A will is a legal document telling a probate court, here's who I want to be my executor, here's where I want my estate to go. It's not just about personal possessions, it's about everything that is titled in your name and is not otherwise transferred. So let's just assume that the bank accounts got transferred. All right, but all of your personal possessions, any accounts you didn't have in the trust, vehicles, whatnot, that's governed by the will, and that means probate, and that's going to be important coming up on this next part. Funeral planning declaration allows one to say exactly what one's wishes are as far as disposition of the body and the services and stuff like that. Yeah, okay. Typically, the way we do it, we have the trustee or the executors, the person who's in charge of making those decisions, and I tell my clients to be as detailed or as general as they want and put it into the big blue binder for estate planning. But now we're getting to the part. If the above documents are done, you can avoid probate. If all of the above is not done, you have to open an estate account at the bank. All money that doesn't have direct beneficiaries goes into this account. You have to have an attorney to open the estate account. No, you don't. The attorney also has to publicize your passing in the newspaper or post publication at the county courthouse. No, it doesn't have to be by an attorney. To allow anyone to make a claim on your property. Here's where it's 100% wrong. Look, it's your executor. That doesn't have to be an attorney. You don't need to hire an attorney, but oh my gosh, if you end up with probate, it does end up being such a pain that most people just want an attorney to handle it. But it's not an attorney that has to do it. And they make it sound like if you've got a last will and testament, great. You don't have probate. Well, wait a minute. This is presuming all of the bank accounts, all of the stock accounts, all the life insurance, all the IRAs and 401ks have proper beneficiaries on them, and they go the way they're supposed to, and you don't have any desire regarding age limits, putting in multiple contingencies. Look, this is much better if you're doing a revocable living trust that can be the core of your estate plan, and now your accounts are in there, and now there's no question. You don't end up, well, wait, I read this post from the American Legion that if all I have to do is have a photo ID and the death certificate, that, well, no, we need you to fill out this form, and we need the letters testamentary from the court. Oh my God. Okay, so now suddenly it's not avoiding probate. Having it in a revocable trust just makes sure that that gets done. Right. So, again, make a list of all bank and account numbers and all investment institutions with account numbers, lists of credit cards, utility accounts, etc. Leave clear instructions on how and when these things are paid. Make sure heirs know where life insurance. Okay. Keeping it all organized, that makes total sense. Having, like, we've got that big blue binder that's got your trust and all your other documents. We have it set so there are places to put all of that information. In a lot of cases, I'm just telling, look, anytime you get your annual statements, either from accounts or maybe even your credit cards, keep copies in that binder so that they have a place to look and check, and it's all in one place. But there was a piece here. leave clear instructions on how and when these things are paid? Nope, doesn't matter. Doesn't matter. It doesn't matter because the law takes over to protect your creditors when you've passed on, so it doesn't matter what instructions you're leaving. And who are you leaving it to? If you've set up all of your accounts to go to these beneficiaries, oh, I've avoided probate, and you've got all these bills, who has to pay them? Now suddenly probate has to happen, your creditors are getting involved, and they're reaching back and trying to pull that money from the people who got your money through these beneficiary designations, and it's a free-for-all. It's even more of a mess. If you've got a revocable living trust and it's in there, just about every revocable living trust that I've read says that you have to be on the hook for paying those bills. So your trustee can make sure it's done and it's not going out to the beneficiaries who are now going to have creditors chasing after them. This could be setting up a huge mess by doing it piecemeal. So, okay. And okay, make sure they know where your heirs know where life insurance is looking. Well, look, your trustee or your executor should also know that. Make 100% sure someone knows your Apple ID, bank ID, account logins, and passwords. Again, it's better if it's your trustee of your revocable trust. Make sure you have titles for all vehicles, campers, etc. Yep, good to have copies of that. Most importantly, talk with those closest to you and make all your wishes known. Talk to those whom you've designated as well as those close to you whom you did not designate. Do this to explain why your decisions were made and to avoid any lingering questions or hurt feelings. All right, that's not a bad idea, depending on your situation, your particular situation. But the fact is, the person you put in charge is the only one who really needs to handle that stuff. When you start doing things by committee, it ends up becoming much more of a mess. Often, my clients are picking a strong person who's going to be the trustee, who's going to say, all right, this is exactly the way it is. This is what they wanted, and I'm going to handle all of this, and here's what the situation is. And they go, oh, okay. Sometimes, again, depending on your family, bringing all that stuff up may actually cause more harm than good while you're alive. Hope this helps. Hope this lights a spark to encourage all of your friends and family to take care of those things and make it easier for those we leave behind. Absolutely. Absolutely. Make it easier. But this isn't necessarily making it easier. In fact, it may end up making it a mess if there's no clear way for your debts to get taken care of, or you forget to change one beneficiary designation when you make a change. And it's all better if you've got a revocable living trust as the core of your plan to take care of all of that stuff. My hope is that the above list at least helps you start an important conversation with your loved ones and an attorney that can help you complete all the necessary steps. Tomorrow is not promised. On that, I 100% agree. Now, again, I mentioned at the beginning of this video, their heart is in the right place, definitely. But it was very clear that that was not written by an attorney, and there are so many holes in it and misleading statements that I felt I just had to put this out there, especially since it appears that this post is going all over the place. Again, I applaud them trying to get the word out there, but the word isn't exactly accurate. So I hope you found that information useful. Please, if you haven't done your own estate planning, follow the advice that they gave to go ahead and get with an attorney to get things started. We've got lots of resources on my law firm page at livingtrustlawfirm.com, as well as plainenglishattorney.com, where we've got links to courses and other stuff that go a lot more in depth than just what's on the website or on the YouTube channel. So, again, as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.